let's assume that your definition of miscarriage, because this is what I'm assuming, you define it as a failure to carry the mail properly. Then loss, to me, and negligent transmission are redundant and useless. Congress knew in the customs duties, custom handling exception, which we looked at in Kawash, how to write a very broad exception that covered everything, intentional and unintentional conduct, but it didn't. It chose very particular words here. And so let me give you some examples I'm troubled by, why they would have imagined that intentional malfeasance would be accepted by this. By the way, I think intentional malfeasance often will be covered by a different exception in the FTCA. In many, some are discretionary, in others, they're outside the scope of employment. There's a lot of other exceptions that cover a lot of the intentional misconduct. But I'm troubled by this. A postal worker refuses to deliver any mail-in ballots from county he associates with a certain political view. Or on election day, the postal worker postmarks some ballots but not others because he's favoring one side or another. This is a miscarriage, isn't it?
Yes.
Okay, so that's exempted. What about when a postal employee writes harassing messages on an individual's piece of mail every day that he delivers it? You are a thief, you're a baby killer, whatever other harassing messages you want. That's a miscarriage. He's not carrying the mail properly.
I'm struggling with that because there's not really anything bad that's happened to the mail in the sense that the mail is getting there on time, it's getting there, the contents are not damaged, it's getting to the right address. But he's not carrying it properly, is he? Well, I think when it's being carried properly, it's referring to the duty of carriage that the post office has to both the sender and the recipient.
And that includes not letting the mail intentionally be damaged. You got to.
Yeah, I think that would be the key question in that hypothetical. Whether you could count that as damage.
How about when a postal employee refuses to take a person's mail in a rural community? There's a post office there. He's supposed to do it, but he forces her to drive 30 minutes one way to a post office who will take her mail.
If it's a situation where the sender has dropped off the mail and the post office...
Don't qualify it. He just doesn't like this person.
Oh, no, we don't. If the mail hasn't entered the mail system...
Well, it's there.
No,
he's refusing to take it to her. That's a miscarriage, according to your definition.
I don't think so, because I think this implicates the line that this court drew.
Counsel, you're fighting the hypotheticals because you recognize, I think, that inherent in using the word negligent transmission, there is a sense that Congress is using this as a verb to start with, and that Congress is looking at these situations in their generally accepted terms. As Justice Gorsuch said, generally we think of loss as negligence. Miscarriage, in all the cases you cite, they all involved non-intentional conduct, except for one, which was a case 50 years before, which really didn't have to do with miscarriage. It was a claim between newspapers, or a newspaper claiming that the post office should have selected it to transmit a message and not someone else. And so even in that case, it wasn't really a miscarriage of the advertisement. It was a failure to deal case. So I guess I'm having a problem with your starting proposition, which is that these terms have to encompass both intentional and or negligent conduct.
Yeah, so with the unintentional line, I would make 3 quick points. One is that if you look at the traditional legal authorities, we look at the evidence of common usage at the time of 1946, none of those authorities draw a line between intentional and unintentional. That's true of the dictionaries, that's true of the decisions. We said on page 9 a number of decisions that use miscarriage intentionally to refer to intentional conduct. Later in our reply brief, we have examples
All of those cases could be distinguished, do you lose?
I don't think so. I mean, we cite a decision involving loss that involves an postal employee stealing the mail. I can't think of anything more willful than that.
Well, that would be outside the scope of his duties, so that would be exempted under a different exemption.
Well, but I think it still goes to what the ordinary meaning of loss was at the time. Maybe another part of the FTCA would kick it out, but our point is that loss had a settled historical meaning, and it covered intentional conduct.
So, Mr. Liu, I mean, this is loss in a particular context. So there are 3 things, basically, that the Postal Service can do to your letters that we're not going to allow you to sue about. So here are the 3 things. They can negligently transmit your letters, and we're not going to allow you to sue about that. Or they can lose your letters. Lose your letters there, definitely not intentional. It's like you lost your keys, you lost your pen, they lost your letters. We're not going to allow you to sue about that. And then there's this miscarriage word that's stuck in the middle of them that's kind of like, ooh, what does that mean? They miscarried your letters. It seems kind of a weird word. But I think I agree with you when you said these are supposed to be overlapping and it's not a big deal if there's some redundancy here. I think that this is, if you look at this statement, it's kind of words are known by the company they keep. On one side, they're losing your letters. On the other side, they're negligently transmitting your letters. And on the other side, they're miscarrying your letters. And miscarrying basically has the same kind of meaning, which is they did something mistakenly with respect to your letters. And that's the way that seems most natural to me to read this sentence.
And I would say a few things in response. One is, I think that Nossiter intuition works only if you, as I think your premise of your question did, buy in that loss refers only to unintentional conduct. We think that contradicts the meaning of loss in the FTCA's sovereign immunity waiver. And
I don't think that that's an argument that works, because if you look at the sovereign immunity waiver, it's using loss in an entirely different way and context. It says the district court shall have jurisdiction over claims for injury or loss of property or personal injury or death. So their loss is functioning as just like one of a number of different kinds of harms that a person can suffer and bring suit about. But this is like losing your mail. That's what this is about. And when you lose your mail, you don't like destroy your mail or tear up your mail or purposefully put them in the trash chute. You lost your mail. They lost your mail. The Postal Service lost your mail. Sorry, you can't sue about that.
I think that setup reveals one of the debates is who lost what. I think it is quite natural to say that respondent lost her mail. Indeed, she uses that same phraseology in
This
her
has
own.
got to be, Mr. Liu, that the post office is doing these things. The post office is negligently transmitted, the post office is miscarrying, and the post office is losing your mail. And notwithstanding that the post office did all those things to you, you can't sue.
I don't think there's a reason to shift perspective from the waiver to the exception. I think
These are 3 parallel terms. You're shifting perspective from loss as opposed to miscarriage or negligent transmission. These 3 terms are the terms that have to be read in parallel form. The post office is doing these 3 things to your mail, and you can't sue about any of them.
Well, Your Honor, I think the better way to read them is that these are 3 harms, just as in the waiver. Loss is paired with injury in the waiver. Loss is paired here with 2 other types of more specific terms that describe injury to mail, i.e. miscarriage and negligent transmission. Your Honor suggested that if you translate them into verbs, there's some parallel structure. That's actually not true. I mean, no one in 1946 would have said the government miscarried the mail. The mail never took the government or the postal worker as its subject. The mail, when miscarry is used as a verb, it takes the mail as its subject.
Okay, but
And that's because, for a reason respondent points out on footnote 19 of her brief, miscarriage is an intransitive verb, just as you wouldn't say the government arrived the mail, so too you wouldn't say the government miscarried it.
I'm